This is Michael Popak with Legal AF After Dark. Remember when Twitter was Twitter and they were, through Elon Musk, supporting Donald Trump and all of his efforts to overthrow democracy? Ah, the good old days. And there's a lawsuit that's now come to a head in the District of Columbia Court of Appeals as to whether Twitter had the First Amendment right to tip off Donald Trump that his Twitter account and all unsent messages, unsent tweets, direct messages, and everything else was going to go over pursuant to a grand jury subpoena and grand jury search warrant over to Jack Smith, the special counsel. Sound interesting? You want to know what the D.C. Court of Appeals, all 12 judges, did with that issue and whether the Twitter would get out from under a $500,000 fine that was sanctioned by Judge Beryl Howell? Tune in to Legal AF, and here's a clip of Karen Freeman McNiffalo and me talking about that very case. Talk about Twitter back when it was called Twitter. So I'll frame it, and then you and I can bounce it around. So Jack Smith, properly for a defendant, a criminal defendant, is known to use social media as a sword and a shield, as a way to interfere with the democratic process and the peaceful transfer of power. Of course, Jack Smith wanted to get his hands on Donald Trump's tweets, not just all the ones that existed, but maybe ones that were in draft, maybe his direct messages, and be able to have the full library of all of Donald Trump's social media for the time period that matters in the indictment. What's a better place to go for that than to have the grand jury issue a subpoena to Twitter? Now, the judge also approved, I guess it was the magistrate judge, also approved a order directed at Twitter in requiring them not to inform the account holder, i.e. Donald Trump, about that, the turnover of those documents for obvious reasons. And there are a series of reasons why you do that, including the possibility of destruction and other things that go to spoliation of evidence and that type of thing. And Twitter didn't like that because they wanted to bend over backwards and help Donald Trump. And so they wanted to be able to, first they didn't comply with the subpoena and wouldn't turn over the documents, requiring a motion to compel and an award of attorney's fees and a sanction by Judge Beryl Howell, who then was the chief judge of the DC court system and presided over all things grand jury, the secret grand jury process. And so she had a full evidentiary hearing. We covered it here on the MeidasTouch Network and on Legal AF. And she heard from the lawyers for Donald Trump. For Twitter, why do you think you shouldn't be sanctioned? You didn't comply. You didn't turn over the documents. You're late. And what about this other part about the First Amendment? And you want to be able to tell Donald Trump against my orders that he not be told. We hear argument on that. When she was done, she sanctioned them, I don't know, $300,000 or $400,000. They didn't like it. They took it up to the Ninth Circuit and the DC Court of Appeals, which is the appellate court for this. And the 3-judge panel said, yeah, no, you lose. The judge was right, Beryl Howell, as she often is, and the sanctions were appropriate. And no, you didn't have any right to let Donald Trump know about it. And so they didn't like that. And so they took an en banc. They asked for en banc review of the order. In order to get en banc, you got to get at least the majority of the judges that sit, I think there's 12 in the DC Court of Appeals, to agree that it's an interesting issue that should be decided by all 12 of them and not just the 3-judge panel that normally makes precedent in any particular court of appeals. So they got there, whatever it was, seven people thought it was interesting. And so they held an en banc. So you go in there, just rows and rows of judges, and you brief to them and you argue to them, and majority wins. So you just got to win by one in that. It doesn't matter. And there was, why don't you take it from there? And I think you maybe even a hot take on it, and go over those that were on the other side, on the Donald Trump side, and those that were on the side of the Jack Smith, and what happened in the en banc decision.
This was a really interesting one, because this really fell down partisan lines, right? The 4 conservative judges, 3 of them are Trump appointees, voted and issued a statement, if you will, or almost like a dissent, with this opinion, because the opinion itself was very, very short. I think it just said denied or petition denied, something very, very short, and that's it. The majority ruling, the decision. But Judge Naomi Rao issued a statement. It was joined by Judge Henderson, who was the judge who listened to the presidential immunity claim, was on that 3-judge panel about a week ago. Judge Katsas and Judge Walker, all Trump or Bush appointees. And what they basically said in this quite kind of a long statement, I think it was maybe a dozen pages long or so, that basically they didn't like the fact that there was this non-disclosure order, right? Where Jack Smith could have gone to the National Archives and asked them for the president's phone, or the tweets, I should say, the drafts, et cetera, because that was all turned over to the National Archives according to the Presidential Records Act. But Jack Smith decided not to do that, and instead to go straight to Twitter to get this information, because the National Archives under the Presidential Records Act then would trigger a notification to Trump, who would then be able to determine whether or not he wants to assert any privileges, et cetera. So A, not only would it slow things down, B, it would make it so that he'd be notified. And just so people understand how prosecutors work, it is absolutely standard course when you have an investigation pending that you don't want the target of the investigation necessarily to be notified about it, because they could destroy evidence, hide evidence, change evidence, etc. And so you want that information to just come to you. And so it is absolutely something that all prosecutors have done. If you are subpoenaing, especially social media information, you don't want them to know that there is an investigation necessarily, and for that reason. And so Jack Smith went to the court and asked them for this non-disclosure for that reason, and he's very open about that. But this dissent, if you will, they didn't like that. And they basically said it deprived Trump the opportunity to intervene if he wanted to. But, the thing is, what I didn't like about it, and what I thought was sort of strange, and why I very much disagree with this conservative dissent, is because there could be any number of privileges that you could assert based on information that you get from anywhere, whether it's an email, whether you get a search warrant for email, or whether you get Facebook or Twitter or any of the places that social media that you could get. And prosecutors' offices, especially Jack Smith, they're going to get stuff that might have marital privilege information, or, who knows, maybe he was communicating with Melania, or it could have attorney-client privilege. Maybe he was communicating with one of his lawyers. So executive privilege isn't the only privilege that could be in any of these communications. And any sophisticated prosecutor, Jack Smith is one of them, will have what's called a taint team. And so what they will do is they will give the information to this taint team, who's a completely separate team from the prosecution team. And there will be a wall, an absolute wall, and no communication. And if there's any communication that is found to be privileged, it gets walled off and the prosecutor will never see it. And so I just didn't understand why the Twitter communications, why executive privilege was somehow would make it so that prosecutors have to do things totally different than they do all across the country in every criminal case where you want information subpoenaed that could have privileged information. But they were very, very much saying that this is, very different here, and that they should have gone the route of the National Archives and done it that way, because that's what they said was Congress was very clear and very careful in providing a procedure for obtaining presidential records, and that should have been followed. But this isn't just obtaining presidential records for historical purposes, or because necessarily you want, who knows why people go back and why a president would want a prior president's presidential records. That's what the National Archives and the Presidential Records Act is about, right? It's not about when there's probable cause that a crime occurred and that evidence could be destroyed, because that's what the judge found, right? That's what you'll find for the non-disclosure. The judge will have to find that there's a reasonable likelihood that the evidence will either be destroyed or secreted or somehow spoliated or whatever the verb for that would be. And so it's very different than just a trip down memory lane or what other reason you would seek to obtain records from the National Archives. So, they go on and on in this statement about the independence of, the separation of powers and Nixon versus United States versus Nixon and citing law that they say has made this case to be a significant departure from historical practice without having to do the things that you need to do in order to justify it. What worries me, however, is this 4-judge dissent just gave a roadmap for the Supreme Court, if they want to, on how to rule against Jack Smith. Now, what happens if this evidence turns out he wasn't allowed to do it this way? I think at worst the evidence gets suppressed. So we don't know what's in these DMs, or whatever the Twitter communications called, because that's the only thing that would be potentially executive privilege here, because tweets are public, right? So they're not privileged, they're announced to the world. But I guess things that are communications between Trump and others while he was president would be the only thing that is in there.
Or unsent tweets.
Or unsent tweets. So so the content of that is, I think, what we're concerned about here, and we don't know what it is because Jack Smith hasn't said it, but I think at worst they just get suppressed.
Yeah, we'll continue to follow it. I'm not that concerned about it. The entire case does not hang on his tweets.
Exactly.
They were mentioned in the indictment in passing, but it's another example of Jack Smith doing really amazing work to leave no stone unturned in locating potentially probative evidence against Donald Trump. And these are things that have his fingerprints on it because Donald Trump either authorized it or tapped it out himself. And it's a great way to hang the person with their own words in front of a jury. Well, there's an example of what we do on Legal AF twice a week, Wednesdays and Saturdays at 8 p.m., only on the MeidasTouch Network. You like lawyers who know what they're talking about? You've reached the right place. Legal AF. And then you can pick us up on audio podcast platforms of your choice. If you know about Legal AF and you like it, thank you for being here and part of our audience. If you have no idea what I'm talking about, that was Legal AF. I am Michael Popak, and you can take that clip and then expect ×5 that we're going to do that kind of hard-hitting analysis at that intersection of law, politics, and justice that only practicing lawyers can do right here. Free subscribe to the MeidasTouch YouTube channel while you got a moment. All it takes is your thumbs and fingers, and we're so close to 2 million. And until my next hot take then, until my next Legal AF, this is Michael Popak reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.